What's going on? I have got a follow-up case. Now, I covered part one, it was last week, sometime Thursday or Friday. This is the defendant who got the court permission to go to Texas, but was in Georgia instead. Yeah, he was ordered to turn himself in with no bond. Hey, props to him for actually turning himself in. He flew to Michigan, or maybe drove, I don't know. He got to Michigan and turned himself in. So, continuance of last week's case. If you haven't seen last week's case, I will drop the link in the description so you can watch the first one. But we're here for round two. And then I got another case for you that's a little bit more serious, but we'll talk about that after this first one. Anyways, I'm Colin. We're cooling. Let's go.
Go ahead.
Thank you very much.
Thank you, sir. Have a good holiday.
Happy Thanksgiving.
Court does call the case. People versus Devon Gallard.
Hey, Alexander, on behalf of people.
And good morning, Your Honor. Attorney Maxwell Dubin, P number 860122. On behalf of Cleared.
Sir, can you? Thank you. All right, what are we doing in this case?
Your Honor, today's the date and time set for PCC. I'm asking for an adjournment of the PCC, and then if I'm able to address bond, Your Honor.
Yeah. You want I can do December 4th or the 11th. He's in custody, so I'm going to go to the 4th. Okay. Probable cause conference, December 4th, 2025, 9 a.m. as to bond.
Your Honor, I believe this court may recall this case. At the last hearing, you revoked bond. My client was intending to, or was granted previously to go to Texas. He did not go to Texas. He returned to Georgia, subsequently revoking bond to a no bond warrant. I want this court to know first and foremost that my client is not here to make any excuses, reasons. He understands that when a court puts in an order, that order must be followed to a T. Doesn't matter what mistakes you make. I think everything needs to be, every I needs to be dotted and every T needs to be crossed. Okay, Your Honor. That being said, I would point out that my client does not have history, a criminal history whatsoever, pretty much and he's never been on a tether prior to this. He did make a mistake. He is owning up to that, Your Honor. What I'm asking here today is that this court either allow him a second chance to prove himself, and in the alternative, give him some type of attainable cash bond. When you did revoke bond, I know obviously court order point that the client drove from Georgia, made arrangements, and turned himself in immediately, showing that he can abide by any rule sanctions this court puts upon him. Just to give some clarity, not as an excuse, the reason he did not return to Texas, Your Honor, is my client was in the military.
I lost you, counsel. I can't hear you.
Can you hear me now, Your Honor?
I can.
Which part did you lose me at?
I don't know because I didn't hear it.
Okay. Well, okay. Well, in short, Your Honor, just some background. Besides, my client does not have a criminal history. This is his first time dealing with something like this. He did not return to Texas. An excuse. He did not return to Texas. His intention was to. That being said, the military, which he was in prior, actually shipped his stuff to Georgia, to his mother's house. That was the reason he did go to Georgia and went to Georgia. What we're asking here today is an attainable cash bond and/or a second chance to prove to you that he can abide by any rule sanction that you would put upon him, Your Honor.
Any response from the people?
Your Honor, at this point, I'm going to object. I don't know. I have concerns. I don't know exactly what he would be saying if he's released. I have concerns that he was given the chance to go to Texas. He told the court and people he was going to Texas. He didn't go to Texas. He went to North Carolina, South Carolina, Georgia, never went to Texas. And I have concerns that if he's released, he's just going to go wherever he wants. And he said last time during the hearing that since he's on the tether, he could just go wherever he wanted. And then I have concerns given that he went to Georgia, and the argument was that if something came up for court, like an exam or a hearing, he had to attend in person. He would be there in person. He wasn't here last time in person. He was in Zoom. The only way we got him here in person was that he had to turn himself in on a no bond warrant. So I have concerns that this time I don't have enough information. Where he'll be staying, what those terms of bond will look like when he gets out, because I don't know if he's going to try to go back to Georgia or if he's going to try to go back to Texas. I just don't know. So at this point, I'm going to object.
Anything else?
Yeah, if I may respond briefly, Your Honor, if my client is given bond, he will stay and remain in Georgia and even come back in person if
How do
necessary.
I know? Know that? Well,
Well, If I
I
may,
mean, because last time he told me he was going to ride in Texas, and I let him leave, never set foot in Texas.
if I may just respond to how you would know that, Your Honor. Besides the fact that he's on tether, he was very upfront with the tether with probation. He didn't lie. He didn't try to say he was in Texas when he wasn't. He was very candid with them when they asked, and he knew he was being tracked and monitored, Your Honor. So his intention was not to deceive you in any way. But that being said, I and my client understand why the court did what they did in revoking his bond. I don't. I want this court to understand that my client is attempting to be very candid and upfront. He's not running away. And the reason, if I may respond to the prosecutor, that he appeared via Zoom is because he couldn't get here in time. So I had him log on because he didn't want to not appear at all. And then, of course, subsequently his bond was revoked and he immediately came back. He's not running from this, Your Honor.
At this point, the defendant's bond will continue as revoked. I let him leave. He told me where he was going. He's now trying to, and never went there. And now he's trying to tell me he's going to some other place. I have no idea. I can't believe this defendant. I can't trust that he's going to do what he says he's going to do. So the motion for bond reduction or bond in this case is denied. This matter is adjourned to December 4th. Thank you.
Thank you for hearing me out. You're good rest of your day.
Childers was around in the building. I felt something. That's why my day has started. Mr. Childers, how are you, sir? And Emily's doing well. I'm glad to hear that. Welcome back. I'm happy to have you back. These people have been out of control. No, it's been really bad. We'll talk. Anyway, court does call the case of the people versus Zipporah Morgan.
Good morning, Your Honor. Jonathan Sachs for Ms. Morgan, who is appearing via Zoom from Georgia.
You last guy there? No kidding. Don't answer. Anyway, state your name, ma'am.
Zipporah Morgan.
Thank you.
All right, that was fun. Yeah, I don't know. You know what? I'm just gonna say I don't know, because I think I would have given the bond back. He went back to Michigan and turned himself in. He knows the rules now, but I don't. Yeah, I'm just, like I said, I'm just gonna stick with I don't know. And then that little funny exchange with the next person that was in Georgia, that was funny. Anyways, we're gonna move on to a serious case. This is in front of Judge Simpson. I kept this in here because this defense attorney is pushing Judge Simpson's buttons. He gets a little frustrated with him. But we are dealing with a serious matter, and I don't want to say it because I don't want the gamers to pick up me saying words that YouTube doesn't like. So this is a time, if you don't like serious cases, you can back out now. But yeah, let's go.
No, you got it. Court just called the case. People versus Samuel, Forbes, Alan, Dabney.
People.
Assistant Public Defender Sandra on behalf of Samuel Alan Dabney. Your Honor, there's been a retained counsel. May I go get him? I believe he's in the hallway.
Oh, was he?
Good morning, Judge. Attorney Chair Richard Fenn, on behalf of Mr. Alan Dabney, appeal number is 42028.
Okay. Good morning.
Good morning.
Your name, sir?
Samuel Allen Dabney.
All right. I understand.
Well, no, hey.
You told me 2 minutes ago. Is that?
You'd want to adjourn.
I believe the defense is asking.
Okay.
Well, no, I'm not. I don't.
It's funny that Miss White is standing up there, not in the middle of the mess. Go ahead.
It's not
For
a mess.
once, I
For
know.
what?
For once.
I'm going to be asking for a preliminary examination, so I don't really need a permit. I just need to.
Well, I don't set a preliminary examination until you have the discovery.
Okay, well, there you go. So
It's like losing a journey.
I need to learn with it.
Okay. Took us a while to get there, but we got there. You want the 4th or the 11th, then?
Since the 4th is my birthday, I'm going to take the 11th.
Then I'll set it for the 4th. December 11th, 2025, 9 a.m. Bond will continue.
And I would like to speak
And
to.
I would just wish you happy birthday, but now you're
Thank
going to ruin that.
I like
Go
to
ahead.
speak to the matter of the bond judge.
Yes.
Felonies on DUI that was like 7 years ago, and that is the only thing that is on his record. This incident stemmed from a matter that happened back in February, January. There was in Canton. This stems from a situation that happened in Canton. My client cooperated fully with the authorities back then. When I say fully, I mean fully. He resided at the same place that when he was arrested back in February, where he got arrested, when he was arrested a couple of weeks ago. In July, when he tried to get some of his phone, his laptop back from the authorities in July, the officer told him then that they were still trying to investigate and charge him with the crime. He tried to flee, trying to get to the point that he knew that this something may be coming down the pike, but he still resided at the same location and didn't try to flee or anything. I believe the bond currently is $500,000, which is might as well be $5 million. I would respectfully ask the court, based upon his non-criminal history and the fact that he did not try to flee, even though he was arrested back in February, was held for a few days. Is that correct? 3 days, fully cooperated with the authorities then, gave statements and everything. And a few months passed when he got his phone advice from the police officers, the detective. They said, "Hey, we're still investigating. They're trying to charge you with this." Still resided at the same location. When they arrested him, he was at the same location. I would respectfully ask the court to give a more reasonable bond. I know the charges, if the judge, he could be in Tahiti right now.
Does he have other felonies pending?
No, judge.
No. Okay. Fine.
Your Honor, I would object. It's my understanding from Mr. Kennedy, as I'm covering this case from today, is that at the next PCC, it's our intention to amend the complaint to amend the charges and add charges of aggravated CSAM possession using a computer to commit a crime, as well as CSAM possession. In this case, it does stem from an incident in Canton where the authorities were investigating a different individual. And in that investigation of that individual, they found a video on that individual's phone that had been produced in his basement with an individual on a video who resembles Mr. Alan Dabney sexually assaulting a child. Through that, they got his phone for this investigation and located an overwhelming amount of CSAM on his device.
On Mr.
Yes, those images include images of children performing sex acts on each other, as well as being sexually assaulted by adults, as well as nude photos. And the report only just gives a small, preview of that. The report states overwhelming amount of CSAM on his device. So I have extreme concerns given that he was investigated for a video of him sexually assaulting a child, which then led to.
You understand now I like to hold on.
Well,
She just indicated it
you
resembled.
need to not interrupt. She
Okay.
did not interrupt you.
She just.
No, what did I say?
I understand, Judge.
Go ahead.
And then now they find all these other images and videos on his phone. So I have concerns would ask that bond remain as set.
What I would like to object to was she indicated it resembles. They had 9 months to determine whether or not this was in fact that a person on the video. And now she's saying resembles, and then 2 minutes later she said it is him. I object to that mischaracterization characterization, Judge.
It was led to him, Sam, on his phone.
And just as I know it may not matter, but Mr. Alan Dabney was involved with this man in a romantic relationship, and this man that they found the devices, he had possession of his devices, of my client's devices. This Tariq Alam person stayed in Canton. The authorities was led to this other individual's location. My client was involved romantically with this person that they arrested and charged back in Canton in February. As I already indicated, Yana, I understand that the charges are serious, but what I really do not like is that when she says resembles, or not. You know, for the past
Maybe that's
months.
the purpose of these proceedings.
I understand, but I don't like the fact that she said resembles and then says it's him.
That led to him, as I'm to understand, and that.
Yes, I'll correct what I said. If the report says resembles, we have to talk with Detective Morrison further to see what that video actually entailed, as it was just the first part of the report. So I'll correct what I originally stated. But that video did lead to them getting Mr. Alan Dabney's phone and locating voluminous amounts of CSAM on his device.
Anything further?
No, Judge. I just think that a more reasonable bond in this circumstance with no prior criminal history would be more like 100,000, 10%, Your Honor.
Well, given that if it was that individual, but then led to CSAM, which was on his device,
which was in the possession of his lover.
You wanna? I'll let you go.
Oh, I'm sorry.
No, I'll let you go. And
I'm sorry. Get a little excited.
because this is going to be a long hearing.
No disrespect, Judge.
Well, it was.
Okay.
Given everything the court has heard, and further that there are additional charges, which I understand are coming in the case, the court does believe that the bond as set is appropriate. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Your Honor, just briefly, may I just respectfully ask for 10% or no?
Bond will continue as set. Thank you.
Thank you.
All right. I told you that one was serious. I mean, I give the attorney props for, going all out for his client, but you got to be respectful to Judge Simpson. He's going to call you out on that every time. And yeah, that's all I'm going to say. I think the for something like that, it should be $5 million bond for a charge like that. That's just my personal opinion. Anyways, that's it. That's all I got. Please hit the like button, subscribe, do all that fun stuff. You know what to do, but that's it. That's all I got. Till next time, bye.
Happy Thanksgiving.